It's also a particular pleasure for me as I'm born and raised in Albany and I'm a proud graduate of Shaker High School. My name is Mary Stone Ross. I was one of the original proponents and co-authors of the initiative that became the California Consumer Privacy Act. I'm no longer a part of that group though, so these are my own comments. Our country is becoming increasingly polarized by the very technologies that were supposed to connect us. As a former CIA counterintelligence officer and counsel on the House Intelligence Committee, I have a fundamental understanding of the power of big data. I've seen it firsthand used to disrupt terrorist networks and stop human traffickers, but I've also seen that power abused by governments and certainly by corporate interests. Regulation must shine a light on what data is collected and grant consumers control over its use and remedies for its misuse so our personal information cannot be used to manipulate and divide us. It is possible to draft legislation that protects consumers' privacy while balancing and businesses' need to collect and use personal information. We accomplished this in California. The CCPA gives all Californians, first, the right to find out what's collected about them and about their devices, second, the right to opt out of the sale, and third, increases fines and penalties for data breaches. Transparency is the cornerstone of the entire law and should be the cornerstone of any good consumer privacy legislation. To date, consumers are consenting to the collection, use, and sale of their personal information without truly knowing what they are consenting to, not because they are ignorant, but it's because it is effectively impossible to be informed. As Atlantic reporter Alexis Madrigal found, reading privacy policies you encounter in a year would take 76 workdays. Businesses have considerable expertise and knowledge about the values and uses of our data. Therefore, in order for the consumer to grant meaningful consent, the business should have the burden to provide clear disclosures. Oracle, a data broker, publishes a data directory of over 40 sources of information that they repackage and sell, including from all 3 credit reporting agencies, and Solve, who verifies that someone is a human from their caption network, which is the I'm not a robot.
Right.
Oracle also sells information from Evite, the popular online invitation service. In the 2017 version of the data directory, Evite says it uses its network of users, which includes consumers who send, but also consumers who receive invitations, including if someone is expecting a baby, if they are moving, traveling, or if they are alcohol enthusiasts. They are getting around the effective Children's Online Privacy Protection Act, COPPA, by collecting information about the age and presence of children in the household from the parents, not from the children. Over a year ago during the campaign, I was interviewed by Deseret News and used this example. The reporter linked to the Oracle directory. Evite refused to talk to the reporter, but promptly had Oracle remove their entry. Evite, although I have a copy, you have a copy too of the one with Evite in it. Evite is hiding their actual business model from consumers because they can, and that they know many consumers would be outraged if they found out what actually happened. Enforcement is key, and I'm glad the New York law has robust enforcement. Quite frankly, this was a mistake that was made in the legislative compromise in California, as the CA's Attorney General's office, who is now the primary enforcer, predicts that even with additional resources, they'll only be able to bring 3 enforcement actions per year under the CCPA. It is possible to draft effective privacy legislation that does not disrupt legitimate business interests. We drafted the CCPA with the understanding that Silicon Valley and technology businesses in California are important to our state's economy and way of life, but also that some uses of data are in fact good for consumers. Thus, under the CCPA, we did not place restrictions on the first party's collection and use of personal information. We consciously crafted the CCPA to protect legitimate business purposes, including fraud detection, fulfilling orders, and even contextual advertising. Privacy, in fact, is good for business and good for competition. As Johnny Ryan, Chief Policy and Industry Relation Officer at Brave Software, a private and secure browser, noted in his recent congressional testimony, today, big tech companies create cascading monopolies by leveraging users' data from one line of business to dominate other lines of business too. This hurts nascent competitors, stifles innovation, and reduces consumer choice. There are several successful businesses that offer privacy-focused alternatives, and regulation will encourage more. I want to conclude with a note of caution. Although the legislative deal in California was struck in good faith, and all parties agreed that some language needed to be cleaned up, there are over 20 bills making their way in Sacramento right now to weaken the CCPA. Thank you for your time, and I look forward to answering any questions.
of you in the room when panel 1 was testifying? Did all of you hear what they were talking about? Okay. So, first question here, right? That was the first question that I asked them as well. How would you define personal data?
I can start.
All right.
I think that when you define personal information, it has to be much broader than what they were talking about this morning. I mean, look, like this is me. This follows me absolutely everywhere as we see, as more and more people have Internet of Things devices. We just bought a new dishwasher, and one of the options was Wi-Fi connected. I don't know why you need a Wi-Fi connected device unless it's going to load and unload itself for me. But there are all of these devices that are collecting information and then transmitting it back. So it's very, very important that it's not just my name, it's not just my social security number, but it encompasses all of these things. One of the approaches we thought about taking was expanding COPPA, but then we decided that privacy is something that's fundamental to every single consumer. And COPPA is a good law. I think, as I mentioned in my testimony, the problem is companies are getting around it by collecting information about children from their parents. So any privacy law should address that and make sure that doesn't happen, and absolutely can't talk strongly enough about the need for true enforcement. And I would also just add, companies should be encouraged to only collect the information that they actually need to collect to perform whatever function or service that they say they're going to do. So, I mean, going back to the flashlight example, because it is so egregious, right? Like, only collect, I mean, I don't even know what a flashlight app needs to collect, other than to know that to turn on that button there, but they certainly don't need to collect geolocation information. I was going to say that privacy should not be a commodity that only the wealthy can afford. And especially a lot of these privacy, the worst abuse says are low income, more vulnerable classes of people. And then also just another note of caution, this was something that really got messed up in the legislative deal in California. So in the initiative, we had a really strict non-discrimination provision. So it said that a business would not be able to deny access, charge you more if you exercised any of your rights under the California Consumer Privacy Act. So it was the right to opt out, but even just all the transparency, the right to know piece of it. So in the legislative compromise, the non-discrimination language was still there, but there was some industry was pushing back, and there were some typographical errors about who had to say the value of the data and who the value of the data was for. So there was, like agreement that this needed to be cleaned up. So now that bill has become a customer loyalty program bill that eliminates any mention of non-discrimination. And in fact, the legislative intent talks about how much Californians love their loyalty programs. Personally, I hate going into Safeway because if I don't put my phone number in, it's twice as expensive as going to Whole Foods. And so these are things that, like you need to go in eyes open that they're gonna push with these loyalty programs, but it's discrimination. And sorry, just to echo that point about loyalty programs, the business is getting a benefit from you being a part of that loyalty program. For example, on airlines, if you're a member of their loyalty program, like that's the pipeline that you're gonna go to, and most likely you're going to come back to them. So selling your information on top of it is just extra ice cream. I have a lot of notes, which I'm happy to share with your office because they're pretty detailed. But one thing that I would say that you got a lot of pushback from the first panel this morning, but it is critical to say that harm is a privacy injury, that you do not tie it to a market-based harm approach. That approach is antiquated and it doesn't work in the privacy context. And so you already have language in there, which is fantastic, and I commend you for that. The only thing that I would add is that in the California law, we allow a third party to opt out on a person's behalf. And the reason why this is important is, as you can see with that Oracle data directory, there's so many companies out there that are collecting, processing, and selling your personal information, and an individual has no idea who these companies are. So it would be great, speaking of another business opportunity or a nonprofit opportunity, to allow other people or organizations to be able to opt out of the sale of your information on your behalf.
and this.
Looking at this on the location service, so my staff member behind me just gave me her Google locator, and I'm looking at December 8th of 2015. Her entire day, even though you can delete some of it, but it's really hard to get rid of this. Every moment of the day, where she was, what she was doing, how many minutes she spent driving in a car from her address to Rite Aid and going to a college and then going somewhere else, that's really scary. What possible reason could they have to keep all this information for all this time? Why would they need to know where I was at every moment of a day?
I mean, the problem is right now, why wouldn't they keep all that information? It's free to hold on to it, and who knows, like maybe there's some use that they haven't thought of yet to keep it. So that's why we need regulation to shift that so there is some cost to holding on and collecting all of that information in the first place.
I mean, I think in some respects there's a value to myself too. Like sometimes I forget what I was doing. I go back to my calendar, you know, and as an elected official, it's important. Sometimes you need to match up what you did on a particular day. If you're filing your financial disclosure forms or you're filing campaign finance forms. But it never occurred to me that Google Locator had my every moment in their system somewhere.
And also, that's your calendar, so you should be able to go back and look at it. But do you want Google and 50 other tracking services and then whoever else to be able to look at that
I think the
information
point
too?
I'm trying to make is most people probably have no idea, right? So you sign up for, you know, you get a Google account. You sign up for rewards at CVS or Rite Aid or Macy's or wherever it is that you do. You do these things because you think that there's a benefit to you personally, and you get something out of it. You get coupons, you get discounts, you get Macy's bucks, you get, you know, the 4-foot-long receipt with, you know, extra bucks, whatever they call it at CVS. So you get something of value. But, so consumers really have no idea that they're doing this. So how do we, beyond the passage of this bill and enforcement, which I'm not sure how we would do that, that's another challenge, how do we raise awareness among consumers that they need to be more vigilant with their data protection on their own?
So one of the ways we address this in California is that if a business is selling personal information, because there's an opt-out, they have to have a button on the bottom of their page that says, "Do not sell my personal information." So it's kind of a public shaming. So AT&T, which you're paying for every month for crappy service, who is also selling your personal information, all of a sudden when you go to pay your bill, there would be a button on the bottom of the screen that says, "Do not sell my personal information." And so what we've seen is that businesses who don't want to be selling your personal information are making sure that they are compliant, so they don't have that button on the bottom of the screen that actually calls them out on what their business model is in fact.
And does the California law have a private right of action?
No, it got taken out. It has a private right of action for data breaches, but it got taken out in the legislative compromise. So this is the problem now. It's just AG enforcement for most of the law, and their office came out and said they only think they can bring 3 enforcement actions under the CCPA a year. But what the initiative had besides the private right of action is we also allowed district attorneys and city prosecutors to bring action under the law.
Have any of them done that?
It's not in effect yet, January 1st, 2020. And just going back to why we had a private right of, I mean, there's a lot of reasons why we had a private right of action in the initiative form, but one of the examples that was really foundational to me was there's a case going against Facebook right now that's progressing through the courts based on the Illinois Biometric Information Privacy Act. And so Texas actually has a very similar law, but in Texas, it's only AG enforcement, while in Illinois, it was AG enforcement, but also a private right of action. And so we see nothing, both of these laws have actually been on the books for many, many years. Texas, nothing happened, but in Illinois, they're making quite a bit of progress.
Very good. Thank you.
All right, thank you all. Panel 2 is dismissed. Thank you.
Thank you.